As Honorable Justice Joyce Madachi. My Lord was a Deputy Director at the Federal Ministry of Labor and Employment for so many years before her elevation to the bench of the National Court of Nigeria. Do you know her? Do you know me, Lord?
No, my Lord.
Did you hear somebody saying yes? Well, my Lord is now on the bench of the NIC. And I have left.
She's welcome, my Lord.
Can you see me, Lord, on my left?
Yes, my Lord.
Very well. My Lord is Justice, Honorable Justice S.A. Yelwa. Honorable Justice Yelwa has been in private practice since 1990. And he has also been a member and chairman of Investment and Security Commission or Tribunal before his elevation to the bench of NICN. So I want to solicit the support of the bar for my lords with me this morning. Peradventure, one of them will be posted to Lokoja.
Please.
So I'll solicit your support for them, wherever you will need to appear before them.
Thank you, ma'am.
I hope I have that support. Positive response from the bar. Very well. So let's go on with the business of the day. Court registrar, call the case.
International. Yes, my Lord. Yes, my Lord.
International Grocery Court of holding at Lokoja. Before Honorable Justice Tuesday, 17th October 2023. Case number 1. NICN LKJ 11 2021 between Onuche Musa Mohammed and 1 Kogi State Government, 2 Kogi State Local Government Service Commission, 3 for local government Kogi State, 4 Kogi State Attorney General and Commissioner for Justice. My Lord,
Party is absent.
Yes, my Lord.
Appearances.
May it please, my Lord. My name is Austin Oboni. I appear for the claimant.
Any other appearance?
May it please, my Lord. FB Obayori. Principal Legal Officer. Well, I appear with DM Okolo, Principal Legal Officer. We appear for the defendants.
Very well. Here is the judgment of the court. This suit was commenced by an originating summons filed on the 8th of October 2021, which was subsequently converted to a general form of complaint by the order of court and later amended on the 12th of October 2023. Claimant v. the complaint seeks the following reliefs against the defendant. 1, a declaration that the claimant, having retired from the service of the defendant as the Director of Local Government Administration, the claimant is entitled to his gratuity, pension, and arrears of salaries accordingly. 2, an order that the defendants pay to the claimant the sum of 28,678,084 naira 92 kobo, being the sum or calculation of A, the statutory gratuity of the claimant, which is 12,957,000 284 naira 8 kobo, as captured in the document dated the 14th of February 2020. The arrears of payable pension of the claimant in the sum of 10,528,280 naira 32 kobo at 289,099 naira 58 kobo per month from the month of August 2019 to September 2022. C, the sum of 5,192,510 naira 52 kobo, being the arrears of the claimant's salary or the claimant for the month of August 2018 to July 2019. 3, the sum of 289,099 naira 58 kobo from the month of October 2022 to the date of judgment. 4, an order of this court directing that the respondent pays the claimant pension forthwith with effect from the month of October 2022. And 5, the sum of 10 million naira as general damages. The case of a claimant has garnered from his amended statement of fact is that he's a retired staff of the defendants who spent about 34 years in service after joining the service in 1985 and rose to the position of a director of local government administration in the year 2014 before he retired with effect from August 2019. It went on that sometimes in the year 2016, his salaries were stopped, but after a legal battle, he was paid his arrears of salaries from December 2015 to July 2018. Prior to his retirement, his salaries for the month of August 2018 to July 2019 in the sum of 5,192,510 naira were not paid to him. He also averred that he was equally owed his statutory gratuity in the sum of 12,957 naira, 284 naira, 957,284 naira 8 kobo as computed by the Office of the Auditor General for local government. It is also his averment that he was equally not paid pension from August 2019 to September 2022, except for the 40% received for the months of April 2020 to July 2020, leaving his arrears of pension for the period at 10,528,280 naira 32 kobo. The total amount owed, including arrears of salary, gratuity, and pension, is put at the sum of 28,678,084 naira 9 kobo. He alleges that the defendants are deliberately refusing to pay him despite having sufficient funds, which situation has caused financial hardship for him and his family, and he has made multiple complaints to no avail, hence this case. The defendants, in response via the amended statement of defense, averred that the payment of 40% of pension in 2020 was not peculiar to claimant because a portion of workers' salaries was reduced due to a shortage of funds. They averred further that pension are being paid monthly to retirees, but gratuity are only paid in installment as the fund becomes available. They maintain that following an audit of the Ogori-Magogo local government, where claimant was director of local government, irregularities by way of irregular payments in the sum of 11.5 million naira made to claimant were discovered. Fraud-induced transactions were also discovered against claimant. The irregular payment and fraud discovery made the defendants request claimant's presence for an audit chart severally, which invitations he failed to honor. His pension payment was therefore stopped, pending investigation into the issue of irregular payment as part of administrative measures taken by the Auditor General for local government, and which stoppage still did not yield any result, as claimant still failed to find out the reason for such stoppage, but instead approached the court. He also averred that over the years, no retired staff of the defendant has been paid up full salary or gratuity due to paucity of funds. On the 21st of February 2023, claimant opened his case by testifying for himself as CWU. He adopted his written deposition of 26th of October 2022. Documents admitted and marked as exhibit to M5 were tendered through him. He was subsequently cross-examined by London Defense Counsel. Afterwards, the case of the claimant was closed. Defendant opened its case on the 20th of March 2023 by calling one Ekpa Monday as his sole witness, who equally testified by adopting his sworn deposition of 2nd of November 2022 as his oral evidence. Documents marked and admitted as Exhibit M to M2 were tendered through him. He was subsequently co-examined by claimant counsel, after which the defense case was equally closed. Parties at the close of trial filed their respective final addresses. I have reduced all that into the body of this judgment. I'll go straight to the decision of the court. Having carefully read and considered all the processes filed in this suit and the arguments of counsel, it is in my firm view that the issues that will best determine this suit are: 1, whether the final written address of the claimant in this case is competent, and 2, whether, having regards to the circumstances of the suit, claimant has proven his case to entitle him to the relief sought. On the preliminary, let me correct the wrong notion stated at paragraph 1.1 of the defendant's final written address, specifically on its second page as to the number of exhibits tendered by claimant. According to defendants, claimant allegedly tendered 5 exhibits in court, which according to him, or according to them, are Exhibit M to M5. Either the approval for retirement of the claimant dated 8th of January 2020, notice from the Office of Auditor General for Local Government, the scale/document of implementation dated 18th of December 2013, a copy of bank statement and return of official vehicles, DLG, and treasure dated 8th of June 2016. The law is settled that what guides the court is its record and no other, as it constitutes step-by-step record of what took place in court, and it binds the court and parties. So the case of Indayako and Muhammad citation captured. Therefore, neither the parties, their counsel, nor the court can read into the record what is not there, and they cannot also read out of the record what is there. They must read the record in the exact content and interpret same. Say the case of H+B, Synergy Limited and another, the Sosisoko Community Bank Limited citation provided. The case of Oguntayo and Adelaja citation equally provided. No other record is expected to take preeminence over court's record as to the veracity of what transpired in the proceedings of court, especially when it becomes a contentious issue. See the case of Access Bank PLC and Sijuade citation also provided. From the records of proceedings, claimant tendered 6 documents and not 5 as proceeded by learned counsel in his final written address, and which documents are Exhibit M to M5, namely the approval of retirement, payment of retirement benefits issued by the Office of the Auditor General for Local Government, judgment of court, and some other court processes, which were admitted together in suit number NICN/LKJ/09/2018, scale of implementation, bank statement of account, and return of official vehicles. Thus, the position of learned counsel above as to the number of exhibits tendered by claimant is not correct, and such cannot be allowed to distort the correct record of proceedings. I so find and hold. With regards to issue 1, learned defense counsel had submitted in paragraph 1.2 of his reply on point of law that the final written address of claimant was filed out of time, because claimant on 20th of March stated that he will file within 7 days, but filed on the 18th of April, when defendant had filed since 4th day of April. Counsel proceeded that claimant as such only has 7 days from the filing of the defendant's final written address to file his written address, which according to him is on the 11th of April 2023, as against the 11th April 2023 when he filed. As reason supra, what binds the court is its record. So the case of Ndayako and Muhammad Supra, Oguntayo and Adelaja citation captured. I must say that I've said through the whole of the gamut of the record of court for 20th of March 2023, and I cannot find anywhere claimant counsel made such assertions that he will file his final written address within 7 days, contrary to the position of learned defense counsel. Now, assuming claimant counsel even made such assertions, which fact is not accepted or conceded, can that be a reason why the court will find that his final written address filed just about 14 days after the defendant's final written address is incompetent? No. Order 45, Rule 9 of the National Industrial Court Civil Procedure Rules 2017 provides those, and I quote, Where a defendant or claimant, due to cogent and compelling reason or reasons, is not able to file his or her final written address within the 21 days or the time limit ordered by the court, he or she may, by an application, request for an extension of time within which to file the final written address, unquote. It is clear from the above provision that parties have 21 days each, or whatever time limit ordered by court, to file their respective final written addresses. The court in this case had adjourned this matter from the 20th of March to 20th of April, 2023 for adoption of final addresses, though it did not give a particular time for it to file. The import is that on that adjourned 20th day of April 2023, the final written addresses of parties must be filed and be ready for adoption. On the 20th of April 2023, when the matter came up, claimant had already filed his final written address. In fact, he filed on the 18th of April 2023 as conceded by the defense counsel. It was on the said 20th of April 2023 that the court ordered that the defendants are at liberty to file a reply on point of law to claimant's final written address already filed. In fact, on that day, the defendants were represented and counsel on their behalf never raised any such objection that the final written address of claimant was incompetent. I'm unable to see any reason why the final written address of claimant is incompetent, having been filed within the stipulated 21 days prescribed for filing same. Accordingly, I find that the final written address of the claimant is competent before this court and thus stands part of the record of this court. EC1 is thus resolved in favor of the claimant. Now to the contention of learned defense counsel at paragraphs 4.5 to 4.7 of his final written address against the admissibility of documents, ES Exhibit M3 and M4, which are scale/document of implementation dated 18 December 2023, and a copy of claimant's bank statement respectively. As regards Exhibit M3, learned counsel contended that the said Exhibit M3 is a public document of which only the certified true copy is admissible, but the one tendered is photocopy and same is untenable. Although learned claimant counsel in his final written address did not deem it fit to address the court on this objection raised by the defense, it is imperative for this court to consider the said objection. Learned defense counsel, by paragraph 4.5 of his final written address, has stated at that point of tendering exhibit that the defense objected to the admissibility of both documents. From the records of court, it is true that during trial, the defense objected to admissibility of the two documents. The basis of counsel's objections are that Exhibit M4 did not satisfy the provision of Section 84 of the Evidence Act for failure to meet the criteria for admissibility as a computer-generated evidence. Nonetheless, the law is settled that a court can only act on admissible evidence and parties cannot by consent rely on inadmissible evidence in proof of their case. The court of law lacks the requisite competence to admit inadmissible evidence even where same was originally admitted with consent of parties. Say the case of Opu and Trust Bond Mortgage Bank Limit PLC, citation captured, Musa and the state, citation captured, and Wagu and Atuma, citation equally provided. Now, Section 102 of the Evidence Act 2011, hereinafter referred to as EA, provides as follows, and I quote, "The following documents are public documents. A, documents forming the official acts or records of the official acts of 1, the sovereign authority, 2, official bodies and tribunals, or 3, public officers, legislative, judicial, and executive, whether of Nigeria or elsewhere. B, public records kept in Nigeria or private documents," unquote. The only 2 copies of public documents that are admissible are either the original document itself, which is the primary evidence of itself, or secondary evidence of same by way of a certified true copy, where the original is not available. See the case of Sterling Bank PLC and Samad Associates Limited and others, citation captured. The case of PDP and INEC, citation equally captured. Does the condition precedent for the admissibility of a copy other than the original copy of a public document in evidence are contained in sections 104 and 105 of the same Evidence Act? Specifically, section 104 of the Evidence Act provides us as to what a certified true copy is. I quote, Every public officer having the custody of a public document which any person has a right to inspect shall give that person on demand a copy of it on payment of legal fees prescribed in that respect, together with a certificate written on the foot of such copy that it is a true copy of such document or part of it, as the case may be. 2, the certificate mentioned in subsection 1 of the section shall be dated, subscribed by such officer with his name and his official title. Such copies so certified shall be called certified copies. 3, any officer who, by the ordinary course of his official duty, is authorized to deliver such copies shall be deemed to have the custody of such documents within the meaning of this section, unquote. See also the case of Tabik Investment Limited and GTB PLC, the case of Wheat Bush Limited and Goodwill and Trust Investment Limited, citation equally provided. It follows, therefore, that the only admissible secondary evidence of a public document is a certified true copy of that document. Thus, by the combined effect of sections 102, 104, and 105 of the Evidence Act, only certified true copies of the photocopies of public documents are admissible in evidence. I painstakingly peruse Exhibit M3, and I find that it is unarguably a public document under section 102 of the Evidence Act, being a document which emanated from the second defendant, and as such qualifies as a document forming the official acts or records of the official acts of official bodies. The said document not being an original, but a photocopy ought to be certified in line with sections 104 and 105 of the Evidence Act to be admissible under the Evidence Act. Learned counsel also objected to the admissibility of Exhibit M4, which is a bank statement, claimant's bank statement, right from when it was tendered, and also in his final written address, on the ground. The same is a computer-generated evidence that was not certified in line with section 84 of the Evidence Act. In response, Learned Claimant Counsel, read paragraph 5.11 of his final written address, had submitted that Exhibit M4 is not a computer-generated evidence, as it is statement of claimant's account and does not fall within the purview of electronically generated evidence as not produced by the witness. He also submitted that in any case, the court is enjoined with section 12, subsection 2, paragraph B of the National Industrial Court Act 2006 to do away with technical justice. In the case of AG of Federation and Anwe citation capture, the Apex Court held that it is the algorithm or data imputed by a bank officer into the bank's database that generates the various information on the statement of account of the customer. The court also further held that the bank statement is a computer-generated document which has to be certified by the officer to ensure that no one illegally or without authorization tampered with the source data as officially imputed in the computer. Also, the certification must include that the computer was operational or in good working order when the document was generated. It is clear from the above decision of the Apex Court decided on Wednesday, the 13th of April, 2022, that a bank statement is a computer-generated evidence that requires certification in line with the provisions of section 84 of the Evidence Act. I'm not unmindful of the second part of the submission of Learned Claimant Counsel, that this court is enjoined to do away with technical justice and depart from the provisions of the Evidence Act while he relied on section 12, subsection 1 of the Industrial Court Act. First, the section relied on by Oboni Esquire is a wrong section of the law. The correct section is subsection 12, subsection 2, paragraph B of the National Industrial Court Act 2006, hereafter referred to as NICA. The reliance of counsel on the wrong section of the law does not mean his submission will be discountenanced. This is because the submission will be considered if it can be premised under an existing or subsisting section of a subsisting law, where the court has a duty to take judicial notice of under section 122, subsection 2A of the Evidence Act. By practice and procedure, the decision of the Supreme Court and all other superior courts are sacrosanct. Therefore, by the doctrine of stare decisis, a lower court is bound by the decision of the superior court at the Supreme Court. The Supreme Court has made it abundantly clear that in line with the principle of stare decisis and strict recognition of its supremacy, as it were, this court must follow its decision. However, the same court allows a court to depart from following its position when facts of a case where the decision was handed down is distinguishable from the one at hand. That is the only instance in which a court can depart from the decision of the Superior Court. This is because cases are authorities for what they decide. Thus, the right to use a decided case as an authority is only applicable where there are no distinguishing features between its facts and the facts of a new case where it is being sought to be applied. Put differently, the age-long doctrine of stare decisis, which obliges lower court to remain bound by the decision of Superior Court, thrives where facts of cases are in pari material. It is lame where the facts of cases are not on all fours. See the case of Anyakura and PDP and others, citation provided. Governor of Ekiti State and another Nguleye and others, citation provided. INEC and another and Ray, citation equally provided. In the above case of AG Federation and Nuebumwa Supra, the trial court was not the National Industry Court, which by its special nature and by the specific provisions of its law is empowered to admit a document, notwithstanding that the said document may not be admissible under the Evidence Act. Thus, the case of AG Federation and Nuebumwa Supra is not on all fours with the present case because the implication of Section 12(2)(b) of NICA was not considered by the Apex Court in that case. By the provisions of Section 12(2)(b) of NICA, this court is at liberty to apply the Evidence Act, but in appropriate circumstances depart from its provisions in the interest of justice of the case before it. The Supreme Court in the above case did not consider the provisions of Section 12(2)(b) of NICA, which allows this court to depart from the provisions of the Evidence Act as I've stated earlier, in the quest for substantial justice. The same Supreme Court, in its recent decision in Coco and others, is a 2023 decision of the Supreme Court, held that technicality is dead and buried, never to be resurrected again, and thus any objection to the achievement of such should be discountenanced. It is noteworthy that the provision of Section 12(2)(b) of NICA was affirmed by the Court of Appeal, Ilorin Division, in the case of Mr. Victor Adegboye and United Bank for Africa, in an unreported appeal number CA/IL/20/2021, a judgment that was delivered on the 14th of April, 2022. NICA 2006 came into force in the year 2006 before the Evidence Act 2011 was enacted. Although before the above case of Mr. Victor Adegboye and UBA Supra, the Court of Appeal has earlier decided that the said provision of NICA cannot operate to encumber the provisions of the Evidence Act. See the decision of the Court of Appeal in the case of SEC and Abilo Boboso. It's an unreported appeal number CA/A/388/2013, a judgment that was delivered on 21st of December 2016. However, the decision of the same Court of Appeal, which came later, that is the case of Mr. Victor Adegboye Supra, held that the above provision may operate to admit a piece of evidence which may be ordinarily inadmissible under the Evidence Act. It is now abundantly clear from plethora of judicial authorities that where the court is faced with conflicting decision of superior courts, the one later in time should be followed. See the cases of Bello and another Nikwe, citation captured, Mujakwe Rue and others, and Ajo Bena and others, citation provided, Osakwe and FCE Technical Asaba, citation provided, Thor Limited and FCMB Limited, citation equally provided. In view of these case law authorities, the decision of the Court of Appeal of 14th of April 2022 will take precedent above the decision of the same court in Oboboso's case Supra. One may want to argue that since NICA came into force before the Extant Evidence Act, reference to Evidence Act in NICA cannot be construed to include the Extant Evidence Act, which came after, but for the repealed Evidence Act 2004, which was the one in force when NICA was passed. The issue has already been addressed by the court in the above case of Victor Adegboye and UBA Supra, wherein the court held that by Section 4, subsection 2, paragraph B of the Interpretation Act, Cap 123 Laws of Federation 2004, where an enactment is repealed and another enactment is substituted for it, then reference to the repealed law shall, after the substituted enactment comes into force, be construed as a reference to the substituted enactment. Therefore, it is clear that reference to the Evidence Act in Section 12(2)B of NICA can be construed to include the Evidence Act 2011, because first, reference to Evidence Act in Section 12(2)B of NICA is not delimited by time or date. Besides, it is clear from the Evidence Act 2011, particularly Section 1 thereof, that what governs admissibility is relevance. Section 2 of the Evidence Act further provides that all evidence given in accordance with Section 1 shall, unless excluded in accordance with the Evidence Act or any other act or any other legislation validly enforced in Nigeria, be admissible in judicial proceedings to which the Evidence Act applies. The above shows that the Evidence Act recognizes the existence of a law validly enforced in Nigeria which can exclude a piece of evidence which is admissible. Again, Section 3 of the Evidence Act provides that nothing in the Evidence Act shall prejudice the admissibility of any evidence that is made admissible by any other legislation validly enforced in Nigeria, which includes NICA. The above presupposes that the Evidence Act takes cognizance of the fact that other legislation may exist apart from the Evidence Act that renders admissible a piece of evidence. NICA is one of such legislation that operates to render admissible a piece of evidence that would ordinarily not be admissible under the Evidence Act. Thus, the provision of Section 12(2)B of NICA is still very much an organic law and can be relied on in this case to entrench substantial justice. It is noteworthy that the defendants in this case are not contesting the authenticity of Exhibits M3 and M4. They are not denying the existence of Exhibit M3 and are also not doubting the authenticity of the bank statement that is Exhibit M4. The said documents are germane for the determination of this case. Besides, the defendants in the amended statement of defense, be it paragraph 1 thereof, already admitted paragraph 4 of the claimant's amended statement of facts, wherein he pleaded the scale of salary contained in Exhibit M3 in proof of his salary. In the same vein, paragraph 5 of the claimant's amended statement of facts, wherein the said statement of account was pleaded, has been admitted by the defendants, be it paragraph 1 of the amended statement of defense. Thus, there seems not to be any dispute to the authenticity or validity of the content of Exhibits M3 and M4. Put differently, the said documents, if considered, will not occasion any miscarriage of justice to the defendants, since their contents have already been admitted by the defendants in the amended statement of defense. Therefore, the admission of these documents, facts linking them, having been admitted by the defendants, will not in any way, in my considered view, occasion injustice to the defendants. It is in the light of the above that I invoke the provision of Section 12(2)B of NICA 2006 and exercise my discretion to depart from the provisions of the Evidence Act to admit those documents. Exhibit M3 and M4 are therefore already admitted on record, stands admitted, and forms part of the record of this court. I so hold. Then counsel also submitted Exhibit M5, which is a letter of return of official vehicle dated 8th of June 2016, was merely dumped on the court without linking it to a particular aspect of the claimant's case. It needs to be stated at this stage that there is a duty on the party relying on documents in support of a case to link every document tendered to the material fact of its case. So the case of Uluashogo and another, an INEC citation provided, Awuse and Udili citation equally provided. A document having been pleaded by a party should be linked by a witness to the allegations and the pleadings. See Bababe and FRN citation captured, Adegoke and others, and Olutin and others citation provided. I've said through the whole gamut of the pleadings of the claimant as contained the amended statement of facts, and I've also perused his written statement of oath and the cross-examination of claimant in this case. I discovered that not only was the document not pleaded or facts contained in it averred in the amended statement of facts, He was equally not linked by the claimant to any aspect of the case. Claimant was equally not cross-examined on it. There is no doubt that this document was dumped on the court. The position of the law is settled that in this instance, where a document is dumped on the court, even when properly admitted in evidence, with or without objection, as is the case herein, or by consent, the document, no matter how useful it could be, will not be of much assistance to the court and the party who tendered them in the absence of admissible oral evidence by persons who can explain their purport and relate them to the case in support of which they were put in evidence. The effect is that the court will not attach any probative value to it. It is in the light of the above that this court finds that exhibit M5 lacks probative value and thus is countenanced as expunged from the court's record. It is also the submission of learned counsel v. paragraph 1.6 of the reply on point of law that the scale of implementation which he tagged exhibit M2, the bank statement which he tagged exhibit M3, and the judgment of court and other processes which he tagged exhibit M4 were dumped on the court by the claimant because the documents were not explained by him as to how much he is entitled to as pension. I'm afraid this submission of learned counsel is misconceived. The document is deemed dumped on court when the document is not linked by witness to the relevant aspect of the case of the part to which it is meant to support as espoused supra. There's no law that says that all those documents must be linked to how much claimant is to earn as pension. It is sufficient if they are each linked to the aspect of the case that they each seek to support. In this era of front loading, a witness will be deemed to have sufficiently linked the documents with the case when it does so through his written statement on oath, which has been front-loaded and adopted as his oral evidence. In support of this position, I rely on the case of PDP and Lechenim citation captured where the Court of Appeal held us, and I quote, "Moreover, in this era of front-loading of cases, where the proposed evidence of the parties are stated on oath and front-loaded in court and merely adopted at the trial, it sounds far short-sighted to expect a party who had adopted his statement on oath at the trial, including his avowals about the documents he pleaded and opted to rely on, to further give detailed oral evidence, again, at the trial, demonstrating how the document he pleaded relate to the case on court. See also the case of Dahiru and Kibu and other citation captured. I've gone through the whole of the 27th paragraph of the claimant's written statement on oath of 26th of October 2022, which he adopted as oral evidence, and each of those documents which were already pleaded in his pleadings were each linked in his statement on oath to relevant aspects of his case, which they each seek to support. More so, the same counsel who is raising this objection had during trial cross-examined claimant on the scale of implementation, one of the documents which he's saying was dumped on the court. He equally asked claimant during cross-examination if he had anything to show how much he's paid, to which claimant responded that the government do not give pay slip, but he has his bank alert, and for which he tendered his bank statement, and the bank statement is one of the documents he's now saying was dumped on the court. The law is settled that document will be said to have been linked to a case through a witness if such witness was cross-examined on that document by the adverse party. Therefore, such document on which a witness has been cross-examined will not be said to have been dumped on the court. On this, see the cases of Bababe and FRN Supra at page 130, paragraph A to C, the case of St. Peter's Parish, Makurdi, and registered trustees of the Deeper Life of Deeper Life Bible Church and others, citation provided. It is in the light of the above that I discountenance the submission made by learned counsel above as to the above documents. Now to issue 2, which is on the cross of this case. A perusal of the originating process evinces that this action is declaratory in nature. The law is of common that a party who seeks a declaratory relief must rely on the strength of his own case to prove that he's entitled to the relief sought. Therefore, a claimant who seeks a declaratory relief needs to satisfy the court on the balance of probabilities to be entitled him to same. As such, declaratory relief cannot be granted in the absence of credible and cogent evidence or on admission of defense. See the case of Adamwa, Nigeria Air Force, citation captured Additional and Air France citation provided. PDP and INEC citation provided. However, the law does not preclude such a claimant from relying on aspects of a defendant's case which support his own. See the case of Hannatu and Amadi, citation provided. Claimant by Relief 1 is seeking for a declaration that he is entitled to his pension and gratuity having retired from the service of a defendant as Director of Local Government Administration. It is his avowment, read paragraph 2 of his amended statement of fact, that he retired as a Director of Local Government Administration and his retirement was approved by the defendant. In support, he relied on Exhibit M, which is the letter of approval of voluntary retirement. According to claimant, prior to his retirement, he had challenged a purported termination of his employment in court, and a judgment of court had been entered in his favor. A copy of the judgment, together with some other processes filed in the said case, is herein as Exhibit M2. Claimant alleged that upon his retirement, his pension becomes payable in August 2019, and that his pension for August 2019 to March 2020 was not paid to him, while the defendants only paid part payment of his pension for the months of April 2020 to July 2020. Defendants on their own part, by paragraph 7 to 12 of the amended statement of defense, aver that it was discovered by the Office of the Auditor General of Police State that certain irregular payments were made to claimant and there were discoveries of fraud on the part of the claimant. The position of the law is clear where there is an allegation of crime in the civil proceeding. The law is on the fair matter that where fraud is pleaded and sought to be established in the civil matter, as in the present case, by the defendant, same must be specifically pleaded by giving particulars of the alleged fraud, and must equally be proved beyond reasonable doubt. Say the case of Agbasi and UBA PLC, citation captured, Alade Shim and Father Hunsi and others, citation captured, Ukoli and Moricab Finance Nigeria Limited, citation captured. Defendants gave particulars of the fraud, read paragraph 11 of the amended statement of facts. In support of the defendant's position, the defendant tendered Exhibit M, the statutory report. Claimant admitted under cross-examination on the 20th of February 2023 that the Office of the Auditor General for Local Government, which issued Exhibit M1, M2, and M3, is the office saddled with the responsibility to audit the account of local government. The defendant had maintained that the pension of a claimant was stopped as a result of claimant's refusal to avail himself of the opportunity of appearing before the necessary body upon invitation for audit charge. In support, they relied on Exhibit M1 and M2, which are the letters of invitation and reminder for audit charge and letter of stoppage of claimant's pension, respectively. Leonard Defense Counsel has submitted read paragraph 5.1 of his final address that claimant during cross-examination admitted receiving the several correspondence inviting him for an audit charge, but stated he did not honor the last invitation. I must say that this is not totally true of the record of what happened during trial. As reason supra, the record of court binds the court and parties. And from the records of this court, claimant was asked questions under cross-examination and he answered those, I quote. Question, you are aware that the Office of the Auditor General is the office that audits the account of local government? He answered yes. Question, you received various phone calls and correspondences from that office inviting you for an audit charge? And he answered yes. Question, confirm to this court that you honored the invitation? He answered, I honored it severally, unquote. It is clear from the above testimony of the claimant that he was aware of his invitation for an audit charge by the Office of the Auditor General for Local Government. In fact, from the above testimony of claimant, he alleged that he did honor the invitation severally, which means he honored the invitation several times. He never stated that he attended all, but not the last one, as counsel would want this court to believe. Thus, there is no doubt that claimant received Exhibit M1, the letters of invitation for an audit charge, even though Leonard Claimant Counsel had tried to make the receipt of the letter an issue while he was cross-examining DW. Also, I bear in mind the submission of Claimant Counsel, read paragraph 5.08 of his final written address, that the invitation was only in respect of irregular payments made to claimant in respect of judgment in suit number NICN/LKJ/09/2008, and not in respect of any other thing. Also bear in mind the response of the defense counsel to same in paragraph 1.7 of the reply on point of law that claimant counsel cannot make submissions outside the pleadings. Let me say that it is the law of commonplace that in civil cases, parties are bound by their pleadings. Allied to this is the principle that court is bound to confine itself to issues raised by both parties in their pleadings. It has no duty to consider issues not properly brought before it by parties, through their pleadings. See the cases of Fodili and Onejeme citation captured, Uzodimma and Ihedioha citation provided. As such, a party cannot orbit outside the facts averred in its pleadings, even in its address, and cannot urge the court to accept facts that are not covered by its pleadings. Claimant in this case is bound by his pleadings, which never stated that the invitation was in payments made to him in respect of the court judgment. Hence, counsel cannot expect the court to declare a state of affairs that was not covered by his client's pleadings. It is in the light of this that I agree with the position of learned counsel for the defendants in his reply on point of law above. Defendant had made the non-appearance of claimant for an audit chart after several invitations and issue in their amended statement of defense. In fact, they averred in their amended statement of defense that claimant refused to attend the audit chart even after several invitations. Claimant never filed a reply to the amended statement of defense. It is the law that a claimant who fails to file a reply to averment in a statement of defense, which has not been taken care of by his pleading in his statement of claim, he will be deemed to have admitted the averment in the statement of defense. See the case of Mugalu and another Mugalu and others, citation capture, registered trustees of the Living Christ Mission and others, this is Aduba and other citation provided, Phillips and Ebautum, Commercial Industries Company, citation captured. Claimant by his failure to file a reply to the averment in the defense, especially as it pertains to the issue of his invitation for an audit chart, and his non-appearance, which are now issues not covered by his amended statement of fact, is deemed to have accepted the above assertions. Besides, the above facts averred in the statement of defense as to the non-appearance of claimant after several invitations for an audit chart was equally reiterated in the testimony of DWU in a statement on oath which was adopted as his oral evidence. Senate counsel for the claimant failed to cross-examine DW on this material point. The law is firmly settled that where a witness is not cross-examined on crucial and material point, the only conclusion is that the adverse party ought to have cross-examined the witness, accept the evidence of the witness as true. So this the case of Dunku and Oa, Nigeria Limited, citation captured. The case of Gaji and Baye, citation provided, Abiodun and the state, citation provided. It therefore stands to reason that failure to cross-examine DW on that material fact of failure of claimant to appear for the audit chart is an acceptance of the testimony. I so find and hold. The defendant, by paragraph 18 of the amended statement of defense, stated that the Auditor General of Local Government, as part of administrative measures taken, wrote to the third defendant directing stoppage of claimant's pension. The letter directing the stoppage of claimant pension, that is SBM 1, reads thus, and I quote, addressed to the Chairman, Bureau of Local Government Pension, Lokoja, Kogi State, titled Stoppage of Salary in respect of Mohammed Unoche. You are to forthwith stop further payment of pension to Mohammed Unoche, a retired head of local government administration to Magogo local government, pending the outcome of investigation on irregular payment made to him. Treat expeditiously, please, unquote. The above captured letter clearly directed the stoppage of payment of claimant's pension pending the outcome of irregular payment made to him. First, it must be stated that the above letter only directed suspension of a payment of claimant pension pending investigation on irregular payments made to him. That is, pending the allegation of irregular payment made in paragraph 8 of the amended statement of facts. Please, I want everyone in this virtual trial sitting to off your phone. I mean, put your phone on silent. Unmute your phone. Unmute your audio. I can see one Infinix Hot 8. You are interrupting the court proceedings. So unmute your phone or your system, Infinix Hot 8. Unmute it. 150317. Unmute your system or phone. Because I don't want to hear any interruption from the people. I'll proceed. Thus, the letter had nothing to do with the alleged fraud claimant was accused of in the statutory report in Exhibit M. I say so in view of the fact that the fraud alleged in the statutory report had to do with huge withdrawals of certain sums and not irregular payments made to claimant. Thus, the allegation of fraud in Exhibit M is clearly different from the allegation of irregular payments made to claimant. Exhibit M2 was only with respect to investigation on irregular payments. It has nothing to do with the allegation of fraud-induced transactions made in Exhibit M. Also, Exhibit M1, which contains the letter of invitation, clearly shows that the invitations are only in respect of alleged irregular payments made to claimant. The invitation had nothing to do with the alleged fraud in the statutory report Exhibit M. There's no evidence before this court that the defendants intend to investigate or pursue the alleged fraud. This court believes that the defendants abandoned the allegation of fraud since there is nothing before this court to show that the defendants took any step after the statutory report. The statutory report, which was for the year 2015, if the defendant had any intention to pursue the said alleged fraud, he will have taken further steps on same after the issuance of the 2015 statutory report till when claimant voluntarily left service and approval of his voluntary retirement on the 8th of January 2020, as seen in Exhibit M. In fact, since the report was submitted to the House of Assembly of Kogi State in line with the provision of Section 125, subsection 5 of the Constitution, there's nothing before this court to show that the House even caused the report to be considered by the House Committee on Public Accounts as provided for under Section 125, subsection 5 of the Constitution. The mere fact that no further steps were taken on the issue of the alleged forgery is an indication that they do not intend to pursue that allegation against claimant. It is clear from all the exhibit tendered by the defendants against claimant that their only grounds against the claimant is in respect of the allegation of irregular payments made to him. I must say that if the defendants want to ensure the attendance of claimant for the audit charge, there are ways it could have been done, and some of these ways are even contained in the repeal and reenactment law. Stoppage of statutory right where there is no law empowering such cannot be a way to ensure claimant's appearance for the audit charge. An illegal act cannot give birth to a legal right. Learned Defense Counsel in paragraph 5.00 of his final written address had referred this court to the provisions of Section 125 of the Constitution, which empowers the Auditor General for local government to carry out investigation and auditing of government accounts. I've read that section, and I must say that there is nothing in that section that empowers an Auditor General for local government to direct the stoppage of pension, which is a constitutional right of a retired officer. If anything, the Auditor General for each state is only empowered by Section 125, subsections 2 and 4, to audit public accounts of offices and submit his report to the House of Assembly of the state and conduct periodic checks of authorities. Just a minute, please. I'm mindful of a provision of Section 10, subsection 2 of the Interpretation Act, Laws of the Federation 2004, which provides those, and I quote, An enactment which confers power to do any act shall be construed as also conferring all such other powers as are reasonably necessary to enable that act to be done or are incidental to the doing of it. The Act of the Auditor General for Local Government directing stoppage of claimant pension, a constitutionally guaranteed right, as will be seen hereafter in this judgment, cannot be regarded as an act incidental to his powers to carry out periodic checks, submit reports to the House of Assembly. Thus, the power of an Auditor General of the state to conduct periodic checks and submit reports to the House of Assembly cannot under any guise be extended to include power to withhold a constitutionally granted right to pension in the absence of any law empowering same. Learned counsel for the defendant had submitted bid paragraph 4.11 of his final address. The failure of the claimant to file a reply to the statement of defense is an admission of the averments of the defendant that investigations revealed irregular payments were made to him. As reason supra, failure to file a reply where necessary is deemed an admission. See the cases of Mwagalu and another Mugalu and other supra, registered trustees of Living Christ Mission and others, and Oduba and another supra. A reply to paragraphs of defendant's amended statement of defense that stated that investigations revealed that irregular payments were made to claimant is essential in this case because the issue is a new issue which the amended statement of fact did not take care of. Failure of the claimant to file a reply is truly deemed an admission of that fact. This is not to say that claimant's pension was thus justly stopped. The court still has to consider the validity and legality of the said stoppage of his pension by the Auditor General for Local Government. Question at this stage is, can the investigation of claimant for an alleged irregular payment or even the refusal of claimant to appear for the audit chart justify the stoppage of his pension by the Auditor General for Local Government? Put differently, this matter falls into narrow compass whether the investigation of claimant for the allegation of irregular payment and or failure of the claimant to appear before the necessary body for an audit chart enough to justify the stoppage of his pension. A perusal of the letter for payment of retirement benefit dated 14th of February 2020, entered as Exhibit M1 by claimant clearly shows that payment of retirement benefit to claimant has been computed and approved by the same Office of the Auditor General for Local Government. The powers to direct for local government. I'm not aware of any law that gives the Auditor General for Local Government the powers to direct stoppage or to stop payment of pension of a retired employee for disciplinary purposes. It is worthy of note that Section 50, Section 2 of Kogi State Public Finance Management Law 2018, hereafter referred to as the PFM law, which was enforced when the letter of stoppage of claimant's pension was issued in 2020, in its part 7, that deals with local government council, provides that the accounts and financial statement of local government councils shall be audited by the Auditor General or his representatives within 6 months after the close of the financial year. Section 2 of PFM law defines Auditor General does, and I quote, Auditor General means the Auditor General of the state or the Auditor General for local government as provided under the relevant part under this law, unquote. It then means that reference to Auditor General under Section 53, under the part which deals with local government, refers to Auditor General for local government. There's nothing in the PFM law that empowers the Auditor General to direct stoppage of a retiree's pension in carrying out acts incidental to statutory audit check. In my considered view, since claimant's voluntary retirement has been approved and the computation of his retirement benefit approved by the same Office of the Auditor General for Local Government, it is beyond the powers of the Auditor General for Local Government to direct the stoppage of his salary and pension. This matter bears some similarities with the case of Morakenyo and Ibadan City Council. Citation is an Apex Court decision. Therein, the appellant was an employee of the Ibadan District Council and retired as a clerk. His retirement benefits consisting of gratuity and pension were granted to him by the council, but the council claimed to be entitled to withhold payment as a set-off against a certain sum in respect of a loss of stores for which it held him responsible, and wrote to his bondsman demanding payment being the difference between the pension and the gratuity. He brought an action in the Chief Magistrate Court, Ibadan, claiming the sum of money which was made up of the gratuity and monthly installments of his pension up to the date of his commencing proceedings. He failed in his action at the magistrate court and further appealed to the High Court, and eventually the matter got to the Supreme Court. In that case, the Apex Court at pages 4 to 6 of the judgment, paragraph C, Brett JSC, when considering the power of the council to withhold the already approved pension, held thus, and I quote, Section 109 of local government law lays down that the governor in council may by regulation make provision with respect to the pensions and gratuities which are to be paid, whether as of right or otherwise, B, to other persons who have been employees of a council or councils. The regulations made under this authority are the local government staff retirement benefit regulations and Regulation 32, on which the council relies, provides that nothing in these regulations shall be construed as conferring a right to a pension or to a gratuity or to an ex gratia allowance as compensation for past service. The question arises whether a right to a pension means a right to be granted a pension or a right to receive a pension once it has been granted. In our view, the context shows that that phrase bears the first meaning. Regulation 7 lays down that a council official may, in stated circumstances, be granted a pension. Regulations 13, 15, 17, and 22 lay down when and to whom gratuities may be granted. Regulation 29 lays down that council may grant ex gratia allowances. Regulation 32 seems intended to make it clear that these provisions are permissive and not obligatory as a matter of law. As regards the payment of a pension once granted, Regulation 12 empowers the council to direct that the pension shall cease on the conviction of an ex-official, but the proviso to the regulation makes it obligatory to restore the pension with retrospective effect if the ex-official receives a free pardon. It is significant that the grant of a pension requires the approval of a permanent secretary to the Ministry of Local Government, whereas Regulation 12 contains the only provision for the discontinuance of pension. It will be inconsistent with the general pattern of ministerial control if a council could withhold a pension at its own pleasure after the grant had been approved, unquote. Taking cognizance of the above captured decision of the Apex Court, it is in my humble view that the Auditor General acted outside the powers of his office when he directed that the payment of pension to claimant be stopped pending the investigations against him. Perhaps he's unaware that the Constitution of the Federal Republic of Nigeria 1999, as amended hereafter referred to as the Constitution, expressly forbids any such withholding of pension or gratuity of a retired public servant by an employer or authority under any guise. Specifically, Section 210 of the Constitution states, and I quote, subject to the provision of subsection 2 of this section, the right of a person in public service of the state to receive pension or gratuity shall be regulated by law. Subsection 2, any benefit to which a person is entitled in accordance with or under such law, as is referred to in subsection 1 of this section, shall not be withheld or altered to his disadvantage, except to such extent as is permissible under any law, including the Code of Conduct, unquote. From the above provision of the Constitution, the right to be paid pension and gratuity is a constitutionally guaranteed right. Such shall not be withheld under any guise, except to such extent as is permissible under any law. There's nothing in the Kogi State Pension Reform Law 2018, which regulates payment of pension in the state, that empowers such stoppage of pension to a retired employee. In fact, from the above provisions of the Constitution, such right to pension as provided for under the Pension Reform Law cannot be withheld or altered. Thus, claimant undoubtedly is entitled to be paid his pension, and I find that the Auditor General for Local Government acted or traversed his powers by issuing the letter for stoppage of claimant's pension after his office had computed and approved same. Claimant's right to his pension, if the defendants must know, is constitutionally guaranteed, and thus none of the defendants, including the Auditor General for Local Government, can alter or withhold it. The pension of claimant is not the personal property of the Auditor General for Local Government, and that he can choose, excuse me, please. The pension of the claimant is not the personal property of the Auditor General for Local Government, that he can choose to compute and approve and then suspend payment as he likes upon the reason that investigation was pending. If I may ask, was the Auditor General suffering from a condition when he computed and approved claimant's pension in the first place? I'm afraid he cannot wake up from that condition now and withhold claimant's constitutionally guaranteed pension. See the case of NNPC and Komolafe citation captured. Abubakar Abdurrahman and NNPC citation captured. I take judicial notice of the extant law on local government audit in Kogi State, which is Kogi State Local Government Audit Repeal and Reenactment Law 2021, hereafter referred to as Repeal and Amendment Law, which repealed Kogi State Local Government Audit Law 2020, hereinafter referred to as the old repealed law. Of importance to this court is Section 52, subsection 3 of the Repealed and Reenactment Law, which contains a savings clause, which preserves all acts done prior to the coming into force of the repealed and amended law. It provides those, and I quote, all actions, audit checks, audit queries, audit exercise findings, opinions, special reports, engagement of consultants, surcharges made by the Auditor General for Local Government or officer acting by his delegated directives before the coming into force of this law, and the existing rights therein are by virtue of this section preserved, unquote. The above provision seems to have preserved all actions of the Auditor General for Local Government, which were done before its coming into force. Also bear in mind the fact that the acts leading to the stoppage of claimant's pension, especially the issuance of statutory report and the invitation to appear for an audit chart and the eventual direction of the Auditor General for stoppage of claimant pensions were all done before the coming into force of the repealed and reenactment law. I say so in view of the fact that the repealed and reenactment law came into force on 29th of December 2021, when it was assented to by the governor, while all the acts done in this case leading to the stoppage of claimant pension were done between 2015 August to 2020. The question that comes to my mind is, can the repealed and reenactment law preserve an erstwhile illegal act, while the other acts of the Auditor General for Local Government may be preserved? The specific act of directing the stoppage of claimant pension in the absence of any law that expressly empowers him to do so is itself illegal and contrary to the supreme law of the land, i.e., the Constitution, and cannot acquire any toga of validity by the provisions of Section 52(3) of the repealed and reenactment law captured above, which is inconsistent with Section 210 of the Constitution as highlighted above. Thus, Section 52(3) of the repealed and reenactment law is to that extent declared null and void of no effect respecting claimant's pension. I so find and hold. It is also the contention of the claimant that he has not been paid his gratuity, to which the defendants responded that for some years now, no retired staff of the defendants have been paid gratuity because of paucity of funds. As reason supra, the right to be paid pension and gratuity is a constitutionally guaranteed right, which should not be taken away except as permitted by law. The defense of paucity of funds put up by the defendant is not tenable and thus unacceptable. It is expedient at this stage that I say certain things as this court is not only a court of law, but also a court of labor policy. It is notorious fact that states are each month giving their monthly allocations in addition to the IGRs of each state. It is equally a fact of general knowledge that is undeniable that elected public office holders and political appointees are paid huge amounts of money as monthly salaries and other forms of allowances while in office. And there is always enough money from the monthly allocation to satisfy that. It is also notorious that political office holders are paid pension when they are out of office. This they do even before they leave office and are paid expeditiously afterwards. Meanwhile, career civil servants who have served this country or their state or local governments are all their life can hardly collect their pensions and gratuity when retired. We as a country need to revisit the ways we treat career, civil or public servants and retirees. More emphatically, all states in this country, Kogi State inclusive, need to revisit how they treat retired public or civil servants, because these are the persons who have used the productive part of their years to serve the state. Payment of their pension and gratuity ought to be given utmost consideration because, as the Englishman says, rest is sweet after labor. How can the rest of a retired public or civil servant after long years in service be sweet when he's being denied his statutory entitlements to pension and gratuity? In view of the above, I find the defense put up by the defendant lame and barefaced afterthought that cannot avail them in this instance. The claimant is entitled to his gratuity and ought to be paid. It is also the contention of claimant by paragraph 10 of his amended statement of fact that he was not paid his salaries from the month of August 2011 to July 2019, which is 12 months. Defendants by their amended statement of defense merely averred by paragraph 2 thereof that they deny all allegations contained in paragraph 7, 8, 10, 13 to 15, 17 to 25 of the amended statement of facts, and shall put claimant to the strictest proof. There are plethora of authorities which say that such pleadings are not sufficient to traverse the specific allegations contained in paragraph 10 of the claimant's amended statement of facts. Say the case of Opala and others under KK citation captured, Union Bank of Nigeria PLC and Chimezie citation captured. Thus it is tried that averment which are general denials in situations where specific are required do not amount to a proper traverse of the case of the other party, and they rather amount to an admission of the case of the other party. From the fact of this case, judgment was given in favor of claimant by this court in an earlier suit filed by the claimant in suit number NICN/LKJ/09/2018. The said judgment is herein as Exhibit M2. According to the facts pleaded by claimant by paragraph 9 of his amended statement of fact, which fact was equally admitted by the defendants in paragraph 1 of their statement of defense, in line with the judgment in suit number NICN/LKJ/09/2018, he was paid his salaries from January to July 2018. Defendants, by their evasive denial, have not denied not paying claimant from August 2018 to July 2019, and they are thus deemed to have admitted that claimant was not paid. However, I'm mindful of the answers given by claimant under cross-examination doors, and I capture it. Quote, question, tell the court if you have been on percentage payment. He answered, yes, it is peculiar to all our staff. Question, from August 2018 to July 2019, all local government staff were paid 40% of their salary. And he answered, yes, unquote. It is clear from the admission of claimant above that all local government staff, which include himself, were paid 40% of their salaries. The effect of an admission against interest is that an admission of fact by a party or his privy against his interest needs no further proof of such fact. CUBA PLC and Joel Ukuriboye Farm Export Company Limited citation captured. Ayoke and Bello citation provided. In fact, the above admission against interest made by claimant during cross-examination that all local government staff, which include himself, were paid 40% of their salaries from August 2018 to July 2019 is relevant and admissible against him. In the case of Abdurrahman and Thomas citation provided, Eco GSC retired held us, and I quote, Evidence either elicited under cross-examination that tends to be admission against interest, vis-a-vis pleaded facts, or that explains an ambiguity created by pleaded facts or evidence already given by the witness is related to the facts in issue. It is therefore relevant and admissible in evidence, unquote. In the same vein, the court in the case of Sulia Mohammed and other citation captured held that the law is tried that an admission against interest made under cross-examination is the best evidence in law. See also Aliu and Inang and other citation provided. It is in the light of the above that this court finds that claimant has been paid 40% of his salaries from August 2018 to July 2019, and as such, what is left is just the remaining 60% of same. Nonetheless, is entitled to be paid the remaining 60%, which was owed him before his retirement. Leonard jurist Idigbe retired held inter alia in the case of NNPC and Komalafe Supra, particularly at pages 73 to 74 does, and I quote him. The porous defense put up by the appellant, as earlier on highlighted, are barefaced afterthought and malicious act on the part of the appellant to deny the respondents his entitlement, particularly his pension and gratuity. Perhaps unknown to the appellant, the Constitution expressly and constitutionally prohibits any employer or authority from placing any obstacle or impediments on the way of an employee as to the payment of his gratuity, terminal benefits, or other emolument already earned to the employee upon retirement, unquote. It is thus clear that any entitlement due to an employee before retirement must not be denied him. It is unconscionable for the defendants not to pay claimant the remaining 60% of his salaries from August 2018 to July 2019. The denial of same without any justifiable reason is unlawful and ought to be condemned. In view of all reasons above, I find that relief one succeeds to the extent that claimant, having retired from the services of the defendants as the director of local government administration, is entitled to his gratuity, pension, and arrears of 60% of his salaries from August 2018 to July 2019. I so hold. Claimant by Relief 2A seeks for payment of the sum of 12,957,284 naira 8 kobo, representing his statutory gratuity as captured in the document dated 14 February 2020. I've earlier found that claimant is entitled to be paid his gratuity, and failure of the defendants to pay him is unlawful. Claimant is claiming, as per the computation on the document dated 14 February 2020, that is Exhibit M1. I peruse the said Exhibit M1 and find that the statutory gratuity payable to claimant is captured as 12,957,294 naira 8 kobo. The said document was made and issued by the Auditor General for Local Government and sent to the chairman of the third defendant. In law, it is not for an employee to calculate what he is entitled to. It is for the employer to do that, and once the employer does that and calculates what the employee is entitled to, the employee can rely on same. Thus, proof of entitlement by an employee is often by reference to an instrument which grants it. Exhibit M1 supports claimant's claim in his Relief 2A. It is only expedient that the court grants it. Accordingly, claimant's Relief 2A succeeds. By Relief 2B, claimant claims the sum of 10,528,280 naira 32 kobo as arrears of pension owed the claimant at the sum of 289,999 naira 58 kobo per month from August 2019 to September 2022. Claimant by paragraphs 15 and 16 of the amended statement of facts have pleaded facts relating to his pension. Claimant pleaded this amount by paragraph 19 of his amended statement of facts and gave particulars of the same by paragraph 18 of the amended statement of facts. The defendant, vide paragraph 2 of the amended statement of defense, did not meet this averment frontally or categorically by a specific averment by way of a denial. They only made a general denial of same, which according to this court is insufficient and will amount to an admission. However, since same pertains to monetary claims, which are in the realm of special damages, same will not merely succeed on an admission. See the case of Aliyu and Bulaki, citation captured. NNPC versus Clifco Nigeria Limited, citation captured. However, in this instance, where the defendant, as in this case, have not specifically denied same or given a contrary figure, only minimal proof is required of claimants. See the case of Wando Nigeria PLC and DJRA WA Limited, citation captured, where the apex court per Akas DSC retired at page 403 held those, and I quote, although the evidence of the value of the burnt down truck is based on the IFC visit of PW5, since the claim was not specifically denied and the defense did not suggest a contrary figure, minimal evidence is needed to sustain this head of claim, unquote. Learned Defense Counsel has submitted by paragraph 4.4 of his final written address that claimant failed to provide any evidence in support of the amount claimed as his monthly pension, and thus his claim must fail. In the same vein, Learned Counsel submitted by paragraph 4.9 of the same final address that since the claimant stated during cross-examination that he had no pay slip in court, there is no evidence in support of his tabular calculation of arrears of pension. I'm afraid this is not the true position and cannot be the correct position from the state of pleadings and evidence before the court. I say so in view of the fact that claimant tendered Exhibit M1, which is a document emanating from the Office of the Auditor General for Local Government, and which document clearly states that the pension payable to claimant per annum, represented by PAA, is a sum of 3,469,194 naira 99 kobo, which leaves his monthly pension at 289,099 naira 58 kobo. This supports the particulars given by claimant in paragraph 18 of the amended statement of facts. Also, claimant during cross-examination, when asked by counsel if he had a pay slip in court to prove how much he was paid, answered us, I quote, "They do not give us pay slip except for bank alert, and have tendered the bank statement," unquote. The bank statement of account herein as Exhibit M4. In fact, a perusal of Exhibit M4, the statement of his account shows that as pleaded in paragraph 16, he was paid the sum of 114,375 naira for April, May, and July 2020, as shown on different pages of the bank statement, and which sum has been deducted under the particulars given in paragraph 18 of the amended statement of facts to arrive at the sum of 10,528,280.32 kobo. In the case of Koshile and Folari, citation provided, the apex court paying Emeka Agbu JSC of blessed memory held us, and I quote, "Where the plaintiff pleads special damages and gives necessary particulars and adduces some evidence of it, without the defendant challenging or contradicting the evidence, he has discharged the onus of proof placed on him, and unless the evidence adduced is of such a quality that no reasonable tribunal can accept, it ought to be accepted. This is because where evidence called by the plaintiff in the civil case is neither challenged nor contradicted, his onus of proof is discharged on minimal proof." CSO Wabuoko PNOT. This principle has been applied in proof of special damage by the Privy Council in Boshali and Allied Commercial and Exporters Limited Supra. Was applied by the Privy Council to restore an award of special damage by a court of trial. It was also applied by this court in the case of Lokoja and Okoronko Supra, unquote. Claimant has led evidence in support of this head of claim, and Exhibit M1 and M4 equally corroborate and support same. Thus, the claimant has discharged the onus of proof placed on him. In view of the above, I find that claimant is entitled to be paid the sum of 10,528,280 naira 32 kobo as arrears of pension from August 2019 till September 2022. Accordingly, Relief 2B also succeeds. Claimant by his Relief 2C is claiming the sum of 5,192,510.52 kobo as his arrears of salary from August 2018 to July 2019. The abandonment of claimant by paragraph 4 of his amended statement of facts concerning his monthly salary as a director of local government administration were admitted by the defendant as reasoned earlier in this judgment. Facts in support of the above sum were pleaded via paragraph 10 of the amended statement of facts wherein claimant gave particulars of this sum. His averment in paragraph 10 above were not categorically denied, and that means an admission. However, earlier, while considering the main relief one, for the reasons given supra, found that claimant was paid half salary, 40% salary for this period, and all that remains is 60% of these salaries. It therefore means that what the claimant is entitled to is 60% of the sum claimed, as stated earlier in this judgment. According to the calculations of the court, which is based on the monthly salary of the claimant, the 60% of the amount claimed is 3,050,704 naira 8 kobo. The law is straight that where a claimant claims more than he can prove, the court can award him the lesser amount, but not more than what the party claims. See the cases of Tower Securities Investment Company Limited and Coronation Merchant Bank Limited citation captured, Okoli and Okoli citation captured, Hassan Nigeria Limited and ACB PLC citation provided. Thus, this court can award claimant the lesser sum of 3,050,704 naira 8 kobo in place of the higher sum of 5,192,050 naira 52 kobo claimed as arrears of salary from August 2018 to July 2019. Accordingly, this court finds that relief 2C succeeds to the extent that claimant is entitled to the sum of 3,050,704 naira 8 kobo as arrears of salaries from August 2018 to July 2019. By claimant relief 3 is seeking for the sum of 289,099 naira 58 kobo from October 2022 to date of judgment, that is to date. Claimant in the relevant paragraphs of the amended statement of facts pleaded his monthly pension as 289,099 naira 58 kobo. In the same vein, I've stated supra that claimant is entitled to be paid his pension and that the monthly pension of claimant going by the computed pension per annum is in the sum of 289,099 naira 58 kobo. In fact, I have in the preceding relief 2B awarded claimant the sum of 10,528,280 naira 32 kobo as his arrears of pension from the months of August 2019 to September 2022. It is only logical that this relief claiming from the subsequent month of October 2022 to the date of judgment, which is today, the 17th of October 2023, be granted. Now from October 2022 till the 12th, till date is 12 months and 16 days. The pension payable for 12 months is 3,469,194 naira 96 kobo, while the pension payable for 16 days is 154,186 naira 44 kobo. And an addition of both gives the total sum of the pension payable from October 2022 to date, which is the sum of 3,623,381 naira 4 kobo. In effect, claimant is entitled to the sum of 3,623,381 naira 4 kobo from October 2022 till date. I so find and hold. Claimant by relief 4 is seeking for the order of this court directing the defendant to pay him pension forthwith with effect from month of October 2022. The preceding relief succeeds. It is only logical that this claim, which is for a consequential order for payment of a pension forthwith, should also succeed. Accordingly, relief 4 succeeds. Claimant by relief 5 is seeking for general damages in the sum of 10 million naira. It is the law of commonplace that general damages may be awarded where a wrong is established. So this case of Kukola T and MTN Nigeria Communication Limited. It's equally true that award of general damages is at the discretion of a court. See the case of MTN and array and other citation captured. General damages, unlike special damages, need not be pleaded. It flows naturally from the wrong complained of, and evidence need not be led in proof of it. The court in the case of Nigeria Bank for Commerce and Industries and Ubemi citation captured opined us, and I quote, "The law is tried that the concept of general damages by nature are those damages which the law implies in every breach of contract and in every violation of a legal right. It is, in other words, a situation where the law addresses the loss or injury which flows naturally from the Defendant's Act and which its quantum needed not necessarily be pleaded or specifically proved, is generally presumed by law and therefore clearly distinguishable from special damages, which concept required specific pleadings and proved by evidence thereof. The case of Ngwachuku and Ebuchu is relevant, wherein ONUJC, as it then was in defining general damages, said it is the loss which flows naturally from the Defendant's Act and its quantum need not be pleaded or proved, as it is generally presumed by law. The principle of obiju v remedium will apply here. There is no wrong without a remedy, unquote. I've reasoned above that the Auditor General for Local Government acted or traversed his powers to direct the stoppage of claimant pension since the year 2020. I've also reasoned earlier that the defense of a defendant stating paucity of funds as a reason for their failure to pay the claimant gratuities against the law and international best practices in law and in labor jurisprudence. One will not be far from the truth if one says that the claimant will have suffered untold hardship since the withholding of his pension and gratuity till now. This may be likened to his right to life, since his livelihood after retirement depends on the payment of his gratuity. It is therefore disheartening and smacks of good conscience for an employer to withhold its employees' retirement benefit for almost 3 years. I find it therefore reasonable, equitable, and lawful in the circumstance of this case to award general damages to the claimant in the sum of 5 million naira as against the defendant. Judgment is accordingly entered in this case. Then I counsel you have the liberty of having clean copies, but I observe some minute typos that will be corrected and forwarded to you in Lokoja.
I appreciate my Lord, sir. I'm very grateful. However, I want to ask for cost. Lord, what cost of 1 million naira, sir? We are just like Oliver Twist, sir. Want to ask for more, sir? Cost of 1 million, sir.
Cost for what? Cost of what? Just cost or what?
No, sir. Cost of
and what are your reasons?
Lord, sir, for having made us to suffer this much and have come to court, sir.
Haven't I awarded 5 million naira?
We are grateful. Sir, we are grateful.
So that's the judgment of the court.
Lord, we appreciate the Lord. Appreciate
Oh, the last case.
Case number 2. NICN MAJ 19M 2021 between Amadou Hussein Albert and 1 Kogi State Government, 2 Kogi State Government, 3 4 PLC. My Lord, the claimant is in court.
Claimant present.
Yes, my Lord.
Defendant.
The third defendant is in court.
Third defendant. Jimoh Balogun. What is his designation? Appearances.
Wait, please, my Lord. I'm Bairi, humbly announcing my appearance for the judgment creditor applicants.
Any other appearance?
No, my Lord.
Any other appearance?
Nil, my Lord.
Very well. So, Mr. Bayeri?
Yes, my Lord.
Mm-hmm.
There has been a partial compliance with the order of the court, my Lord.
Very well. What exactly has been done?
The judgment creditor applicant have been paid. Judgment creditor applicant have been paid April 2023.
Speak out. Has been paid to when?
From April 2023.
From April 2023
To date.
till date.
So last month, my Lord.
Till last month, till September.
Yes.
We are still in October. And that means that he will be paid subsequently.
From my Lord, from September 2017 to March 2023 has not been paid. 6 to 7 months.
Mr. Bayeri, I want you to place your phone before you and check your audio so that I can hear you clearly. You said he has been paid from April till September this year.
Yes, ma'am. Yes, ma'am.
Okay. So what is the outstanding payment?
The outstanding payment is for 67 months.
Is for what?
That is to say, my Lord, from September 2017, when judgment was given, till March 2023.
They've not paid that. They've not paid from September 2017 to March 2023.
Yes, my Lord.
So what are their reasons? What are their reasons?
No, I don't. The reason is that they don't have funds, and then I don't which I can't believe. The
secretary, Mr. Balogun, what do you have to say to this?
Yes, my Lord. I'm here to give a report of complete compliance. I'm sorry for not coming. Hello, ma'am. I'm sorry for not coming to
Very
I
well.
wish to inform you that we have complied with the court order. The judgment creditor is now paid from the month of April 2023. Then the outstanding arrears.
Just a minute. Take it one after the other because I'm noting you down. You wish to inform the court that the judgment creditor has been paid his pension from when?
Yes, from April 2023.
April when?
April 2023.
2023.
Yes, my lord.
Till?
Yes, till September.
September this year. Yes, that is what Mr. Bayeri said.
Yes, my lord.
So how about the arrears?
Yeah, the outstanding arrears is paid as at when we request a gratuity. So the pension board is currently at the fund, and then they have applied to the government.
Mr. Balogun, I won't release you until that is done.
My lord, I don't have power to
but you can influence it as the educational secretary. That's why I won't allow you, I won't let you off the hook. You can influence it as an in-house person, as an official of government, you can influence it. And I believe that it because of your intervention, that this payment had been paid, the one that was paid from March till September.
My lord, that's true.
I mean, from April to September. So I want you to put in your best again to ensure that that is done, because tomorrow you are also in office.
Okay, my lord.
Very well. Thank you for the efforts made already. And I want to encourage you to do your best again and ensure that the judgment creditor is being paid fully his dues. Right?
My lord.
Very well. So what date?
12th December, my lord.
From September 2017 to March 2023. What date again?
12th December.
Very well. It is good to know that judgment creditor has been paid his pension from April 2023 to September 2023. It will be paid in subsequent months. It is thus incumbent on the judgment debtors to pay the outstanding pension from September 2017 till March 2023. Mr. Balogun is hereby urged to ensure expeditious payment of same to the judgment creditor. Case adjourned to 1st of December 2023 for report of compliance.
As God pleases.
For the next
I am most grateful, my Lord.
Very well.
Case number 3. NICN LKJ 2019 between Samuel Babatunde Abata and 1. Kogi State Government, 2. Kogi State Local Service Commission, 3. Chairman Kogi State Local Government Service Commission, 4. Local Government Area, Papa, 5. Chairman of Local Government Area. My Lord, the claimant is in court. Defendant acted, my Lord.
Appearances.
May it please my Lord, Tunde Olowo, appearance for the claimant is in court, Your Honor.
Very well. Any other appearance?
May it please this honorable court. My name is Oluwafemi O Adegoyega. State legal advisor. I appear with my learned friend, V.A. Shaibu, legal officer.
E.A. Shuaibu.
V.A. Shaibu, my lord.
Very well.
We appear for the 1st to the 3rd defendants.
Respectfully, my lord. I'm O.W. Obaido. I appear with I.C. Duke, and our humble appearance is for the 4th and 5th defendant. Agree.
Are the defense ready today? Okay, Mr. Adegboyega. Mr. Adegboyega.
Yes, my lord. Yes, my lord.
You are to cross-examine CW.
Yes, my lord. But however, the claimant's counsel filed a reply to our statement of defense and also accompanied him with a further witness statement on oath.
Further witness statement on oath. So definitely CW will still have to be recalled.
Yes, my lord. That was the order of court.
Yes. So invite CW, Mr. Olowo.
Mr. Samuel.
Administer the oath on him.
I, Samuel Babatunde Agbaja.
Swear in the name of God.
Swear in the name of Almighty God.
That the evidence I shall give in this case.
That the evidence that I give in this case.
Shall be the truth.
Shall be the truth.
The whole truth. And nothing but the truth.
Nothing but the truth.
So help me God.
So help me God.
My Lord, witnesses are so good.
Mr. Samuel Agbaja.
Mr. Lowe, when did you file that process?
It was on the 26th May.
Okay. Go ahead.
Sorry, my lord.
Go ahead to his further deposition.
You made a further deposition before this court. Sorry, my lord.
Hmm? 26th of May, 2023.
You made a further deposition on the 26th of May, 2023.
Mm-hmm.
Yes, sir. Yes, sir. Yes, my lord.
You want to adopt same?
Show him.
Okay.
Yes. Yes, my lord.
Very well.
You want to adopt same as your further deposition matter?
Yes.
Any document, any additional documents?
There is no additional, my lord.
Very well. Is that all for him?
That is all for him.
For examination.
Thank you, my lord.
Sir.
Yeah. Okay.
My lord.
Okay, my lord, may I respectfully apply for the exhibit? No.
Very well. They are there. Court registrar, hand over the exhibit to Learned Counsel.
Take a look at exhibit A3.
A3 is what?
Is the offer of promotion, my lord. Offer of promotion.
Very well.
Yes, my lord.
You have seen the document.
Yes, sir.
Now open to the second page of that document. Now tell this court from that document your date of birth.
My date of birth was on 24 February 1974.
Very good. Now,
sorry, what date?
On 24 February 1974. To the best of my knowledge, I might believe.
(1974).
Now,
Go ahead.
look at Exhibit A4. Exhibit A4 is the employee biodata form. The employee biodata form.
Yes, thank you.
Did you fill that form? Did you personally fill that form?
Yes, I did.
Now tell this honorable court what your date of birth on that document is.
What is it?
Where? Which area?
Check it, look at it. If you feel
you
you know where you put your date of birth.
Still the same things.
What is the date?
On 24 February 1974. Still the same thing.
Very good. Now, on that same document, on that same exhibit 4, A4, I want you to read out the portion, the last corner to your left, where your thumbprint and your signature is. Please read out that portion where your thumbprint is.
I cannot see clearly. I can't see clearly. I can't see clearly. My Lord, I can't see clearly.
Eh?
I can't see it clearly.
You can see it clearly. But
Yes,
you
it's
saw,
painted.
listen, but you saw your date of birth.
Yes, yes, my Lord.
So why can't you see that, your signature or your thumbprint?
My Lord.
Eh?
The printing of that paper is not clear to me, my Lord.
So you don't know whether it's your thumbprint there or is your signature. Did you thumbprint? That's why I don't look at copies. I can't find it. Eh?
Yes, my Lord.
Send the code.
That's
It's my thumbprint, my Lord.
Thumbprint or what? Eh?
Yes, my Lord.
Is your thumbprint?
And your signature.
Yes, my Lord.
Now, what I want you to read out that portion just before your signature and your thumbprint. If you have your glasses here, why don't you take it?
Are you using glasses, eyeglasses?
Yes, ma'am.
Collect it and put it on.
Yes, my Lord.
So you can see clearly.
Now this is clear now.
So put it on now. Mr. Idigbe.
Where's your glass?
I never knew I would. Something.
And you say you never know. My Lord.
My Lord, in the court, I don't come with my glasses.
You didn't come to court with it?
Yes, my Lord.
Okay, but you can see what learned counsel have asked you to look at.
Yes, my Lord.
So look at it and answer.
I say my thumbprint.
Okay, let me, my Lord, if I can read to him.
Okay.
So that he can now confirm. As the court pleases.
Just a minute, Mr. Olowo, did you front load that document?
I front load.
You front loaded it with the original processes.
Very well, my Lord.
Go ahead, Mr. Idigbe.
In that place, you said, I, Agbaja Samuel B. do solemnly affirm that all the information above are true and accurate. If found otherwise, I am liable to dismissal from the local government civil service and prosecution. Then you signed and you put the date there.
My Lord.
You confirm.
Yes, my Lord.
My Lord, he confirms the statement on Exhibit A, at the foot of Exhibit A4.
Go ahead.
Now, did you attend Government Technical College, Lokoja?
Yes, I did.
Between 1980 and 1982.
1982. Then I was.
No.
Just a minute.
Question.
Did you attend Government Technical
Government
College?
Technical College, Lokoja, between 1980 and 1982.
No, I attended Government Technical College in 1980. 90s.
1960.
No, Mama. I attended Government Technical College 90s, not 80, not 80.
Listen, witness, sit down. Let them give you a seat to sit on. Is there a seat there?
He's already seated.
You're already seated. Place the phone before you. Talk to the phone so that I can hear you properly.
Put the phone before you.
You said you attended when?
He asked me a question. I attended. I said yes, I did.
But which year did you attend?
90s.
Now listen to the question and answer.
Place the phone before you. Can you see me?
Yes, my Lord.
Yes. Put the phone before you like this and talk to it. Don't
My
look
Lord,
at it.
I attended
Yes.
Government Technical Lokoja, not 80s, but 90s.
Tell me the particular year.
Where is it?
Tell the court the particular year that you attended. Yes.
Ask the counsel.
The particulars are not here.
You don't know when you attended Technical College, Lokoja?
I knew, my Lord.
So tell me when.
19th, within 19th.
Claimant.
Not 80s, it's 19th upward. We were here, my Lord, when they created the Kogi State.
So you don't know when you attended Technical College, Lokoja?
I knew, my Lord.
And so tell the court.
1982, 1980. My Lord,
yes.
Give me chance.
I'll give you a chance.
At the court pleases.
I'm giving you a chance now. Think about it properly.
It was 92. We finished. My Lord. My Lord.
I'm here.
I entered Technical College 1992.
You entered.
My Lord, sir.
My Lord, let it be on record.
My Lord, there was not.
I'm not even, I haven't heard him.
My Lord, was not.
Mr. Samuel Babatunde Agbaja.
My Lord, sir.
When did you attend Technical College Lokoja?
1997.
You said I should give you time. I'm giving you time. Just don't look at anybody in the courtroom. Don't look at anybody. Just sit down quietly. Think about it.
My Lord, this document was not sent up to my file.
My Lord, sir.
Yes, Mr. Lowo.
The question my friend is asking is not contained in the script, my Lord.
But counsel can, under cross-examination, can ask any question that regards to the educational qualification of your client, because he worked with the defendant.
Very well,
and it is that he attended Technical College, Lokoja. And the question has been put to him, which he answered, but the issue now is with the date. That's why I'm giving him time. He said I should give him time. I'm giving him time. Let him think about it. What date? Allow your witness to tell the court. If he doesn't know the date,
my Lord, I said the 90s.
In the 90s.
Precisely, I can't know the date. Yes,
because
my Lord.
The 90s start from 1989, 82, 80, whatever. So, and counsel had asked you whether it's between 1980 to 1983. So if you can't remember, if you don't look at the court, no.
My Lord, what I recollect, I was there, we were there when they created Kogi State.
So you don't have any certificate for attending Government Technical College, Lokoja?
I have my certificate, but I didn't take that.
So you can't remember when you attended the school. So if I ask you when you attended primary school now, you can't remember. Remove your finger from the face of the camera. Court clerk, show him how to handle it. So if I ask you when did you attend primary school, you can't remember.
No, I'm confused. I have so many things on my head since this work.
Mr. Idigbe,
Yes, my Lord.
We have to proceed, though.
As the court pleases, my Lord, I believe that
so you can address the court on this.
As the court pleases, but my Lord, I would want it to be on record that the
that thing is appalling.
mentioned several dates.
Mr. Idigbe, that is appalling when you start telling the court what to do, what to put down, what not.
My Lord, I apologize.
I've put down what I believe is the right thing. Proceed from there. Go ahead.
As a copy, my Lord, I apologize. My Lord. Now, where is that Government Technical College, Lokoja? Where is it located? Where can we find that institution in Lokoja? Government Technical College.
My Lord, to that question.
Yes.
I'm objecting to that question, my Lord.
Yes.
The issue at today is forgery of primary school certificate. I don't know why my learned...
not technical college.
Not technical college, my Lord. It's primary school.
Mr. Idigbe, I actually wanted to ask you that Is this really, really germane to your case before the
Lord,
court?
my Lord, it is very, very germane. And we are
Because according to your learned friend, he said the issue that you raise in your defense has to do with the primary school and not the government technical college.
My Lord,
and you know, you can't dance outside of your pleadings.
My Lord,
the rhythm of your dancing steps has to follow the beat of the pleadings.
As the court pleases, my Lord. My Lord, everything that I have asked is contained in our pleadings. And if my Lord will permit me, I will point the specific paragraph of
your defense.
Of our
when
defense
did you
out.
file your defense?
And my Lord, we refer to all of these dates and documents. And we told the court that we are going to rely on this document. My Lord, our defense. My Lord, we even concluded this document. Understand what my
so just go ahead. The court will look at it in your final written address, Mr. Olowo. Raise it if they didn't plead, then the court will expunge it. Or discountenance it.
So my Lord, my question to him is, where is the location of Government Technical College, Lokoja? Where is it? Where can we find that institution in Lokoja?
During the creation of Kogi State, our school government college was made the secretariat. Those who are living in Lokoja, they know where it was located. Those who are living in Lokoja, then
it was turned to which secretariat? Sorry.
Yes, when they created the Kogi State, our school was made the secretariat. Then.
And so is it the secretariat in Zone 8 or which secretariat?
My Lord, yes. I didn't know the street name.
As the court pleases, my Lord.
Very well.
Now,
go ahead.
Now, that institution is a secondary level institution. Am I correct or wrong? Is it a primary school or it is a secondary level?
You mean the Government Technical College?
Yes, my Lord.
All I know was technical college. Technical college.
Mr. Idigbe, it goes without saying that cannot be a primary school.
My Lord, I needed to let the witness. My Lord, now witness, were you issued with a certificate?
Were you
issued with a certificate?
I was issued, but it's not one I tendered here.
You were issued with a certificate?
Yes, my Lord.
It is not
tendered here. And it's not what we are
my Lord. My Lord, the contended is the primary school certificate.
Mr. Olowo, I've just gone through the defense filed by Mr. Idigbe by the first to the third defendants. Paragraph 14 talks about a government technical college, Lokoja. I've just seen it. So please let Mr. Idigbe go on. In your final written address, if you feel that it wasn't part of their pleadings, you can address the court on it.
Okay, very well.
About other matters. I have some counsel here in Abuja waiting for their matter.
Very well.
So you said you were issued with a certificate.
My Lord.
Now, did you give your employer that certificate at any point?
Yes.
that he gave a copy of that certificate to the employer.
Go ahead.
Now, in 1982, you were issued, 1982, my lord, you were issued with a trade test certificate.
Yes, my lord. Who are a written test certificate. Because then, in primary school,
to the question.
My lord.
Listen, he had not asked you any other question than were you issue a trade test certificate, and you said yes. That's all. Then allow him to ask any further question.
My lord, I want to go further.
You cannot go further. It is what we ask you.
Go ahead, Mr. Idigbe.
Now, do you remember when you wrote the exam that culminated in the issuance of that certificate to you?
You are not traditional.
Sorry, I didn't hear you.
That's the question.
Sir.
My lord, he concluded it. I think he should be shown the certificate. He concluded the certificate, trade test certificate.
No, let the witness talk to the court. You are not the one giving evidence, Mr. Odowo.
My lord, I wanted to see the certificate.
You did what?
The one is referring to.
So do you remember when you took the exams before you were given a trade test certificate?
That was the time we were in primary school. Based on our hard work, some 9 of us were picked to go and write the exam, of which I am one of them. Then certificate was to us. Then in primary school, every day we used to have a craft. Based on our performances, we were appointed to go and write exam. 9 of us. Then I came up with that.
So that was when you wrote the exam. Go ahead, Mr.
Yes, my lord.
It's connected. Are you going to the town? Even if it's in the car, they will just rub this thing.
Mr. John Barra. Mr. John Barra, please mute
yes,
your
my lord.
phone.
Yes, my lord.
Please mute your audio. Very good. You are interrupting the court proceeding. Go ahead, Mr. Idigbe.
Now, looking at you have told this honorable court that you were born on the 12th day of February, 24th February 1974. Now take a look at exhibit A5.
Which is?
My lord, exhibit A5 is notification of certificate, and it has attached to it a primary school certificate.
This letter. This is a letter of complaining I've written when they accused me of having a forgery certificate.
No. I've not asked you any question. I said you should take a look at it. Look at the second page.
This my case.
Yes, the second page, the certificate itself. Yeah.
What?
Now, what is the date of birth of the owner of that certificate? What is the date of birth of the owner of that certificate?
What is the date of birth on that certificate?
It's not by us. It is our teacher that filled it that time. Because of our...
No, that's not my question. You are not answering my question. My question is, what is the date of birth of the owner of that certificate?
He has the right to qualify your question.
Mr. Olowo, if you interject again,
my lord,
foreclose your witness.
You said certificate. Sorry, my lord.
There's a simple question. What is the date on that certificate? Date of birth.
Date of birth of the owner of that certificate. What is it?
Second one. I can't see it. Okay. It was dated 1960. You can see that.
No, just answer the question. Just
the date of birth.
The date of birth.
Which is not my handwork. I'm not the one that filled that form.
Yeah, but tell me what is there.
Just tell us what is there. We did not say whether you are the one that filled it or not.
What is the date of birth of the owner of that certificate?
My lord, based on what they did as at that time, because it was called 1964.
What date? Just 1964. Just 1964? No
Yes,
month,
my lord.
No month, no day.
I'm claiming that I'm not the one that filled it that time, my lord.
Yes, but tell me what is there.
1964.
Okay.
Now, still look at that exhibit. Tell the court when that person started primary school. Tell this court when that person, the date, the day, you can see it there. Tell the court. 1970.
1977. That is what they wrote there.
No, check it. It's 1976 stroke 1977. Check it properly and tell the court.
What is there?
1967, 1967, 1977. That is what they wrote there. I've said this that I'm not it.
Listen, 1967 stroke 19 what?
1977, my lord.
Very well. Next question.
What is the date from that document? The date the person graduated from
primary school?
From primary school, yes.
Is that not what he said?
No, is the date of entry. That is
the date of entry.
Yes, it's 1976 stroke 1977.
'87. I can't see clearly.
So when did the person finish primary school?
Is it 1981? 1981 82. 1981 1982.
Very well.
Now, finally on that exhibit, look at the page 1 of that exhibit. Yes, page 1 of the exhibit. Is there any evidence whatsoever on the face of it that it was received by the office that you sent it to? Is there any acknowledgement on the face of it?
Yeah, that's what I'm saying.
Is there anything on the face of that document that shows that it was acknowledged by those people that you addressed it to?
Why there's no?
Is there any acknowledgement on the face of that document? Yes or
It
no?
is because I'm not attended to. I've written this letter of complaint. They are not listening to my complaint.
As a complaint.
Listen, witness, is there any acknowledgement or any receipt or any signature on the front page of that document?
My lord, there's no signature.
Very well.
So that document was not, you said it was not collected from you, or it was not submitted.
This letter I've written, I copy the Civil Service Commission, the government house, local government.
The question is, was it accepted? Was it accepted from you?
Yes, they collected it from me. It was collected from me.
As a couple, yes, my lord, on that witness.
That's all.
On that exhibit, my lord. Now, at paragraph 25D of your witness statement on oath, you stated
the original witness statement.
Yes, my lord, the first witness statement, my lord. You stated that your monthly salary is 81,332.
Yes, my lord.
Is there any document?
81,000.
81,332 naira. 3 kobo. Now, my question is there any payslip or any official document which you have which show this figure as your salary?
Thank you, my lord. My lord, during the time of
it's a yes or no answer.
During the time of
yes or no answer.
Financial class.
My lord,
you give us
my lord,
our salary.
The witness is not answering my question.
It is our finance class that give us
witness
what we are taking.
I am to ask and you are to answer. Is a yes or no answer. Do you have any document with you now?
Document I wrote there.
Where's the document?
That's what the one you are reading.
I'm not reading from any
document. Any document to confirm this salary?
Any official document?
We are about to do screening. They ask us to go to our finance clerk to obtain the amount we are collecting monthly. We went to our finance clerk.
All of that.
Yes, my lord.
Statement. You have said all of that in your statement. My own question is, do you have a document?
That is the document I've written there.
Which document?
The one he has just read, my lord.
Any document?
That's not a document, that's a pleading.
My lord, can I interject? My lord.
Witness, did you tender anything to show that your salary is 81,332 naira 3 kobo?
Yes, my lord.
Very well.
When we are about to do screening, they asked us to go and meet our finance clerk. Through our finance clerk, we were able to get. Yes, my lord.
And you have tendered it in this case?
Yes. It is from there. From.
Go ahead, Mr.
When you were summoned to appear before the senior management committee, did you appear?
There was no time they invited me for senior management committee. Neither written or oral. I was not invited for anything.
As a club.
Go ahead.
That will be all for this witness.
Very well. Mr. Obaido, I think you have already cross-examined the witness. Mr. Obaido. I said you've already cross-examined the witness.
Yes, my lord, we initially cross-examined the
based
witness
on the main.
In view of the additional statement. Yes, my lord, we just want to ask like additional 2 more questions, my lord.
Very well. Go ahead.
Yes, my lord. Witness. Confirm to this court again when you were dismissed from service.
You were what?
Dismissed from service. The form. My lord is.
I was dismissed from service on 17 November 2018.
2018.
Yes, my letter was given to my Lord.
Next question, the second one.
Exhibit 10. Yes.
Which exhibit?
Lord, exhibit A9.
A9. A9.
Yes, my lord. A9 is the bank statement.
So go ahead with your question.
Sorry, my lord. Just a moment, my lord. Please, please confirm to this honorable court on the 25th day of April, and just to read out to the court the transaction details. During this.
The transaction details of what date?
25th April.
25th April, which year?
Which year?
25th April 2020.
Right? That was the statement of account. We had to go on print when we are about to do screening.
In Sobaido,
Can you?
the
Yes,
transaction
my lord.
details of 25th of April, which year?
2016.
Okay. And what is that? Witness. Read it out.
My lord, I can't read it. That was the statement of account. My lord, the statement of account we had to obtain when we are about to do screening.
My lord, I wish to read to
Hearing of the witness, and we wish him to confirm.
Then go ahead.
Witness, and we wish him to confirm.
You just want him to confirm.
On the statement, my lord.
This is out nice.
Mr.
It reads, my lord, Ogomagogo February salary.
You just want him to
confirm,
Give it to
my
the
lord,
witness to
that
look at it.
particular.
Give it to the witness to look at it and tell the court.
Sorry, my lord.
Give it to the witness and let him look at it and tell the court what is the narrative there, or the narration.
My lord, I cannot see anything.
You can't see it.
I can't see it.
Okay, court clerk. Court clerk.
Yes, my lord.
Do you have exhibit A9 with you? You have it with you?
Yes, my lord.
A9, yes. Look at what transpired on 25th of April, 2016. It's 24th, so you said 24th of April or 25th. Oh yeah, 25th of April. Go ahead.
Ogorimago salary. Let's check.
Yes, my lord. That is what is there.
So what is the amount there?
My lord?
What is the amount there?
₦100. Under reference,
under lodgement. Look under lodgement.
Under what, my lord?
Lodgement. I can see 4,000.
4,000. 586 naira 21 pesos.
Yes, Mr. Obaido, you said 2 questions. So are you okay?
My lord.
Said you are going to ask only 2 questions. You've asked 2 questions.
As a court,
is that all? Is that all, Mr. Obaido?
Of the first to 12 defendants also.
Rely on our previous
very well
questions and the process
well.
to 12 defendants.
Any re-examination?
Just one, my lord.
So that's all for CW.
I have read, my lord. Just one.
Go ahead with your re-examination. I can't see you, Mr. Lowo. Witness, remove your hand behind the camera. Mr. Lowo, unmute your phone. Unmute your phone. Unmute your audio.
Very well, my lord. Take a look at A4.
Exhibit what?
A4.
A4 is what?
That's the form during
the form that he filled when he said he attended government college.
No, not at all.
Okay, okay, the form he filled.
My lord, I object to this line
I can't even hear Mr. Lowo. Mr. Lowo, place your phone before you and talk to your phone so that I can hear you. I don't even heard your question. What is your question? Go ahead, Mr. Lowo.
The figure, that is the amount. How did you come about it? Salary.
Sorry, my lord.
What's your question?
This amount as salary.
We are being directed. Before I meet our financial.
My lord, my lord.
No, just a minute. I haven't even gotten Mr. Lowell. You're asking about the amount of salary or what?
On that A4.
Yes.
I said, how do you work?
We got this one.
My lord, object. My lord, we object that line of question.
Mr. Olowo. Mr. Olowo, what was your question?
The salary amount contained on Exhibit A4.
How did he come about it? The document speaks for itself.
As the court pleases, it's not ambiguous, very clear.
The document should speak for itself.
As the court pleases.
If he's not the one that puts the amount there, then he's not.
As the court pleases.
Exhibit A was given to him, am I right?
Very well.
No, he filled it by himself.
Well. So Exhibit A4 shouldn't the amount stated therein shouldn't cause a problem. The court will look at it. Re-examination. Any more?
No more.
Very well. Is that the case for the claimant?
That is the case for the claimant.
Very well. CW, you are finally discharged. Your case is closed. You have another date for defense?
Yes, my lord. My lord, it's adjourned to tomorrow, today and tomorrow, my lord.
Okay, case stands adjourned to tomorrow for definite defense.
As the court pleases.
Next case.
I'm most grateful.
Case number 4. Case number 4. NICN LKG 08/2023 between Alex Obori Ovanja and 1 Board of Trustee Evangelical Church Winning All Equal. 2 Reverend Dr. Yunusa S. Madu. 3 Reverend Baba Jere Jethro. My Lord, the claimant is in court.
Appearances. Defense. Is the defendant in court?
No, my Lord. Please
With
represent.
profound respect, my Lord.
Idu
Adeju. I therefore the claimant, my Lord.
Any other appearance?
Respectfully, my Lord.
I hope you are connected so that.
Yes, my Lord. Respectfully, my Lord. I'm PP Shanding.
Shanding.
SHANDING. For the defendant, my Lord.
Very well. Have you filed your defense?
My Lord, we were served with the complaint on the 28th of September. And we are still within time to file our defense.
You are still within 14 days?
No, we have filed our memorandum of appearance.
Doesn't matter. You're supposed to have filed your defense. We don't do proceedings here like that. You file together.
As God pleases.
When do you want to file your defense?
My Lord, we will apply for a short date to enable us file our defense. I said we will apply for a short date to enable us file our defense.
Mr. Adejuma.
Yes, my Lord.
I hope you have heard the Learned Defense Counsel.
I've heard him, sir.
Any objection?
No objection, my Lord.
Agree to a date. What date? Court registrar suggests the date for them.
April, my Lord. November.
No date. December date.
Okay. They say December. First, my Lord.
What's that?
What date?
12th, my Lord.
12th
of December?
Yes, my Lord.
Is it convenient, Mr. Shandin?
Yes, my Lord. I'm most grateful, man.
Defendants are to file their defense within 7 days and serve advance copy on the claimant. Pleadings are to settle before the next date by consent of counsel. Case adjourned 12/12/2023 for hearing.
As copy.
As a copy.
Mr. Shandin, you have to pay for default fees.
Copy.
Very well. Call the next case.
Case number 5. NICN LKJ 29/2022. Nigeria Union of Road Transport Workers. And 1, Madam Baba Isa Salu, Malam Bala Isa Salu, trustees of Kogi State Owners Association of Nigeria. My Lord, parties absent. Between and two trustees.
Appearances. Appearances.
Most humble and respectfully to my noble Lord. Yizo Guma is my name.
Spell it, please.
Yizo N-Y-I-O.
N-Y.
I-Z-O.
Okay, Yizo. Then Guma.
Guma. G-U-M-A.
Very well. You are for who?
With me is my learned friend, C.O. Ademola Esquire.
For
our humble appearance is for the defendant.
Claimant to
the defendant.
Claimant is not represented in court. I can see Mr. Barra online. Where is he? Claimant was represented by Mr. Barra, J.U. Barra. Is he in court? Is he online? Court registrar, is there Mr. Barra in court? Court registrar.
No, my lord.
Okay. So, Mr. Guma, what's the business of the day?
We have a pending motion on notice.
When was it filed?
It was filed on the 24th of June, 2023.
To regularize your counter affidavit?
Yes, my lord.
Have you served a copy on the claimant?
Yes, my.
You have served the claimant.
And subject to copy. Yes, my lord. And subject to the overriding convenience of the court, we are ready to move same.
Go ahead and move it.
We are most grateful, my lord. Our motion on notice is dated and filed on the 21st of June 2023. It is brought pursuant to the provisions of the law as demonstrated at page 1 of the motion paper. Praised before 2 reliefs as disclosed at page 1 of the motion paper. Is a 10-paragraph Deposed to by Comfort Omoni Ademola. Attached to the motion are 3 exhibits. Exhibit NJ1, NJ2, and NJ3. Exhibit NJ1, NJ2, and NJ3. In compliance with the rules of my noble lord, we have filed alongside a written address. The written address is dated the 21st day of June, 2023. Reliance on all the paragraph of the and as well adopts in the grant our application in the indication. We are most grateful, my lord.
All eyes are sprayed in a motion filed by the defendants on the 21st of June, 2023.
We are most grateful, my lord.
Very well.
In view of the application just granted, my lord, we shall be asking for a date to enable us file and serve
clean copies.
List of documents and written address to originating summon of the claimant. And we also believe that on that day, the matter will be ripe for hearing. As pleadings.
Defendants are to file the clean copies of the processes within 48 hours and serve them on the claimant. Court registers for hearing.
We are most grateful, my lord. What date?
What date for hearing?
13th.
13th of what?
13th.
13th of what? Convenient.
It's convenient, my lord.
Case adjourned 13/12/2023. Hearing notice to be for hearing. Hearing notice to be served on the claimant proved to be filed.
As court, please. We are most grateful, my lord.
Very well. Call the next case.
Case number 6. NICN LKJ 26-2022 between Mr. Ajayi Adekunle Olamilekan and Lapo Microfinance Limited. My lord, the claimant is in court.
Or his counsel. The judgment creditor, who is in court? Claimant is in court.
Yes, my lord.
Defendant.
Absent, my lord.
Appearances. Any counsel in court or online? Unmute yourself. Unmute your audio so I can hear you.
May my noble lord be pleased.
Yes.
M.O. Idigbe is my name. For the defendant.
No appearance for the claimant.
No, my lord, but the claimant is present in court.
Claimant, where is your lawyer? Okay, he has never been represented by counsel.
No, my lord, he was.
He was. Olumoko. One
Yes,
SD Olumoko.
Yes, my lord.
So, claimant, where is your lawyer? Since the first appearance, he has never come back to court.
Yes, my lord. For the past 3 months, my lawyer abandoned me and he stopped picking my calls.
Have you perfected your brief? Have you paid him?
Yes. Yes, my lord.
You have paid him?
Yes, my lord.
So have you tried to find out from him why he's not been coming to court?
It just happened. There is one certain time he asked me to send some money to him, my lord, that he want to appear in court and wish no date for my case. When I confirmed, I made him to understand that such things never happened. Since that moment, he stopped picking my call. Until yesterday, he sent someone to me that to appear in court myself if I won my case. That's why I appeared myself, my lord.
Are you sure you paid him for him to file this process as illegal fees?
Yeah, well, before filing the case, everything asked me to pay, so I paid, my lord.
You paid.
And after that,
okay, if you can handle your case yourself, or maybe you report to the Nigerian Bar Association and let them talk to him.
Yes, my lord.
Which of the two options? Would you like to prosecute your case yourself, or you will report to the Nigerian Bar Association, or you go to Legal Aid Council? Which one is that?
Or let me plead with you, my lord, to give me a little time to look for another lawyer, my lord. I want to plead with the honorable court, ma, to look for another lawyer, my lord.
So, Idigbe.
But it's only fair and just to allow the claimant to talk himself out.
Very well. So
We
what
have not even closed pleadings from the last time we filed a statement of defense and regularized 20th of March till this moment. They have not even taken any steps. They have not even filed reply. Maybe they abandoned it. I don't know. That's where we are.
You've heard the reasons given by the claimant.
That's why I said it's only fair and just to allow him the opportunity to sort himself out. In the interest of
So what date? Court registrar suggest date.
14th, my lord.
what is what?
14th December.
Okay. The Thursday. I think the Thursday.
It is in the interest of justice to enable claimant to obtain the service of another lawyer that this case is adjourned 14/12/2023 for further mention.
As a conflict.
Call the next case.
Case number 7. NICN LKJ 14M 2023 between Mr. Obdoma David and 1 Judicial Qualified number 2 Mr. DJ Okai, number 3 Alphonsus Ogun Esquire, 4 Chairman and member Kogi State Qualified. My lord, party absent, my lord.
Appearances.
May it please, my lord. My name is Oboni.
For who?
R.O. G.R. Ocholi. I hold the brief. G.R. Ocholi. Ocholi is O-C-H-O-L-I. Not for the creditor applicant.
Very well. Any other appearance?
May it please this honorable court. My name is Oluwafemi O. Adegboyega. State legal advisor. I appear with my learned friend, V.A. Shaibu, legal officer. My lord, we appear for the judgment debtors, my lord.
Very well. Any of the Ganish's lawyer in court?
My lord. Unmute yourself.
Unmute your system, Techno SQ. Unmute your phone.
Okay, my lord. Okay, my lord. I'm online now.
Go ahead.
May it please this honorable court, my lord. I am S.O. Ademu. I am S.O. Ademu, representing the First Ganishi Bank, Unity Bank PLC.
With profound respect to this honorable court.
Any other?
Yes, the second and third Ganishi is represented. The second and third Ganishi is represented. I am M.A. Omada.
Your name is?
M.A. Omada. Holding the brief of S.S. The honorable appearance is for the second and third Ganishi.
Holding the brief of S. What?
S.S. Uda.
Holding the brief of who?
S.S. Uda.
Uda.
Yes. UDA. Double A.
For who? For which of the garnishes?
For the second and third garnishi.
That's First Bank and United UBA.
Yes, my lord.
Very well. Have you complied? Have you filed any affidavit to show cause?
Please, my lord.
Yes, Mr. Idigbe.
My lord, we became aware of these proceedings about 2 days ago, my lord. And we have, as of yesterday, filed an affidavit of
You became aware of it when?
about 2 days ago, my lord. 2 days ago, my lord.
2 days ago will be on Sunday.
Yes, my lord. It was an unofficial information that this matter was coming up.
So you weren't served with the order NISI?
None, my lord. Stand to be corrected. From the information available to me, from the judgment debtors, they were not served with the order NISI.
Just a minute.
As a copy.
Mr. Oboni?
Yes, my lord.
The judgment debtors were not served?
I cannot attest to that, but I believe they should have been served.
Well, I'm looking at the case file. I can see service on Unity Bank, First Bank, UBA. I can see that Ministry of Justice Lokoja received the enrollment of order on the 16th of October, just yesterday.
Okay.
So, Mr. Idigbe, you are right. So what is the state of affairs?
The simple fact, my lord, is that this matter is, the appeal had been entered at the Court of Appeal, Abuja Division.
When? Which paragraph of your affidavit of first stipulates
my lord,
that?
My lord, we'll look at, my lord, paragraph 3. Paragraph 3, sub D, my lord. Paragraph 3, sub C. Sub C, sub D carries the appeal number. And my lord, paragraph E carries the counter affidavit filed by counsel who commenced the instant garnishee proceeding. This counter affidavit that
Paragraph,
you filed at the
first paragraph what?
paragraph 3, paragraph 3C.
3C.
Yes, 3C talks about when the record was compiled
and
transmitted. Paragraph D evidences the appeal number. Paragraph E contains the counter affidavit in opposition to a motion for stay filed by counsel who commenced the instant garnishee.
It was filed where? At the Court of Appeal?
Yes, my lord, at the Court of Appeal.
Okay, I hope you attach all that.
Yes, my lord, we attached it. It is Exhibit KOSCOE2. That is the counter affidavit filed by the same counsel who commenced this garnishee proceeding.
Very well. Mr. Oboni, you have a copy of the affidavit of facts.
Yes, my lord, but I would like to differ a bit, sir.
Okay. Go ahead.
I would like to just look at the annexure, the first annexure, the exhibit A, sir, or the exhibit 1, sir. It's a notice of appeal. That shows that the appeal is incompetent.
It shows that what? It shows that
the appeal will not go well. They don't have the right to appeal direct, sir. Appeal had to be by leave, sir. They are not sure. They don't file the appeal. They are appealing against the High Court.
They said the decision of lower court complaint of the whole decision.
Yes, sir.
They didn't say whether it's on fundamental right.
Yes, sir.
Or not.
My lord, my lord,
please let me finish.
Okay, please go on.
Mr. Adegboyega, let him finish.
As the court please.
So, my lord, just a look at the notice of appeal, sir. Shows no issue to try, sir. The decision of sir, set fundamental right issue, sir, that could be appealed as of right. Instant appeal that they are relying on is a basket that cannot hold water, sir. And now
you can't be arguing that here because let's look at the attachments together. Yes, there's a notice of appeal, and then
yes, my lord.
They have mentioned fair hearing.
As the court pleases.
It means there's no need for leave.
Ground one is very clear.
Appeal. That's
and
their
my
ground
lord,
one.
This is never the fora to contest whether
I've said so, Mr. Adegboyega.
Pleases, my lord.
I've said so. So, Mr. Awoni, that has taken care of your first concern. So let's look at the second one. Which other one?
My second concern, sir, is that the decision they seek appealing is the
Let me ask you a question. Did you file a counter affidavit? Mr. Oboni, did you file a counter affidavit at the Court of Appeal?
Yes, sir.
In this matter?
Yes, sir.
As annexed to the affidavit of fact?
Yes, my lord. Yes, my lord.
Very well. So it means you agree that the Court of Appeal is seized of this matter?
As the court pleases.
It is plain on the affidavit of fact filed by the judgment debtors that the Court of Appeal is seized of this case. Thus, this court has no more power to sit on it. To do that will be foisting a situation of helplessness on the appellate court. It is in view of this that this case is adjourned sine die until the determination of the appeal by the Court of Appeal.
Let's go, please.
Call the next case.
Case number 8. NICN.
My lord. My lord. I'm so sorry. I'm so sorry. My lord, I apologize. I apologize. My lord, the order nisi of this honorable court is still extant. And if your lordship adjourns this matter sine die, the funds in the hands of the garnishees
will be charged.
Bound, is still finding the funds of the judgment debtors. So, my lord, I believe it is only right.
Okay.
That the
order nisi is hereby set aside.
As the court pleases. We are most grateful.
On the 11th of July, 2023. So the order nisi is set aside, the garnishes are discharged.
It's a copy. We're most grateful.
And in other words, I can't even adjourn. So if at the end of the day, the judgment creditor has judgment from the Court of Appeal, if it's confirmed, then they can come back and file a new process.
That's a copy.
Yes, it is in view of this that the order nisi given under the hand of this court on the 11th of July 2023 is hereby set aside. The garnishes are discharged. Which one is this? Call the next case.
Case number 8. NICN LKJ 10 2022 between Joseph Francis and 1 Sinoma International Engineering Company, 2 Dangote Cement PLC. My lord, party absent.
Appearances.
Please, my lord, and P.
Oh.
I appear for the defendant, sir.
Any other appearance? Kneel in the open court. Any appearance for the claimant online? Kneel for the claimant.
Kneel for the claimant. Yes, my lord, sir. My lord, sir, the matter was slated for definite hearing, sir. If my record is correct, sir. And the matter came up last on the 21st of June, 2023, sir. That is about 4 months ago, sir.
Claimant counsel was in court and consented to this date.
Yes, he was in court. He was in court. Even before that date, the previous adjournment, we had 2 previous adjournments at their instance. And he was in court the day we take this date for hearing. Even the order of the court that it
so what do you want the court to do?
I urge my Lord, sir, to evoke his power as conferred by Order 38 Rule 3 of the rules of this honorable court, sir. And struck out this matter, sir, for lack of diligent prosecution, sir. The defendants are always available so that whenever the claimant is fully ready, they can come back, sir. That is our humble application, my Lord. Or in alternative, if my Lord is inclined to grant more adjournments, sir, we shall be asking for a cost of 20,000 naira. Most grateful to the honorable court, sir. Because it clearly shows that they are not ready to prosecute this matter again.
Court registrar, what date?
Put it, my Lord. No, it's further adjourned. It's adjourned for 2 days, today and 19th.
How about if you are not going to be on the 19th?
Ask up, please.
So it's better to So what date is convenient for you?
14th, my lord.
14th
December.
of December.
Yes, my lord.
Okay. It is true that at the last sitting, Clement and his counsel were in court, and counsel consented to today's date. Clement has not shown any reasonable cause for his absence in court today. However, since today is the first time of his absence in court, the court will oblige his absence and grant an adjournment to enable him prosecute his case. Case is thus adjourned to 14th of December 2023 for hearing. Cost is to be in costs. Hearing notice from the claimant proved to be filed.
Ask up, please. Most grateful to the Lord, sir.
Very well, thank you. Is that all for Lokoja?
Yes, my lord.
I'll rise from Lokoja.
Call.
All right.
Thank you.
Thank you very much. Thank you. Thank you, sir. I need to go to this place.
Police
This man can enter me come. This very one. Udiba.
Yes, sir. Yes, sir. The magistrate is on this. Is it Danjuma?